Ladies and gentlemen, dear colleagues, dear researchers, it's a great pleasure for me to welcome you in Luxembourg and at the Max Planck Institute Luxembourg, and luckily the weather is with us. This conference is the outcome of a collaboration between the Max Planck Institute and the Vrije Universiteit of Brussel, sorry for the accent. And I have to say that it has been initiated upon the impulse of young researchers, namely Tamar and Marco. You have almost all know them. And they came to us and convinced Erik and I of the interest of joining freshwater and salted water in a single but very ambitious conference. And we were indeed convinced, but we considered that they had to learn something, especially that for a conference like this one, you need a rather solid budget. And therefore, we decided that to prepare an application to the Fonds National de la Recherche du Luxembourg, where the project was very well received. And I want to express our very warm thanks to the FNR for the support. Asaël Rouby was representing today the FNR. We'll say a few words after me. So we speak about young people, and indeed we speak about people who provide their energy, who come with new ideas, sometimes naive, but always refreshing. And we need them. And this is why we thought that they should have a place in this conference. So besides gathering almost all the most prominent speakers in the field, the conference offers an exhibition of posters giving account of the research of young researchers. The posters are either in the coffee room or beside the stage, and I invite you very warmly to visit these young researchers during various breaks along the conference and to talk with them. They will be available and happy to do so. The conference would not have taken place without the support of the very devoted staff of the Institute, and I'm very grateful. I want to thank very warmly Nathalie, Martina, Sabrina, Thomas, Johannes, Simone, Elk, Fabio, Tobias, and all the people without whom this would not have been possible. So I'm very grateful. They do a very great job, and they do it even more than expected. You can see all the layout of this conference, and it owes a lot to them, and I'm very grateful. A few logistical remarks before giving the floor to Erik for the scientific aspect of the conference. The coffee breaks will take place here. You have seen the coffee room. The lunch and the reception will take place upstairs at the 4th floor. You will have to take the lift. Do not look for stairs. If you do not have a badge of the Institute, you will be trapped in the stairs. So please, either you're with a researcher or you take the lift. So it might be that it's a bit crowded to go up, but for the coffee and the dessert, it will be downstairs. So we expect a rather smooth circulation between the 4th floor, where you will find very fine terraces where you can enjoy fresh air during the breaks, and the ground floor. One more element, PowerPoints. Some speakers will have PowerPoints. We have screens there. We were not able to provide other screens for the back of the room due to security reasons. So this is why people sitting in the back of the room have paper versions of the PowerPoints in case they are not able to see the screens. So this is the explanation. This being said, I wish you a very nice conference, the rationale of which Erik will explain now. Thank you.
Good morning. As the co-organizer of this conference in Luxembourg, I would also like you to welcome you a second time, this time on behalf of the Vrije Universiteit Brussel. In Belgium, we are not allowed to translate this because in French it means exactly the same thing. And then there would be a problem of association of if you write articles and you put simply Free University of Brussels, people would not know whether it's the French or the Flemish university. So it's a no-go. We cannot do that. So for that reason, I'm sorry, we have to pronounce these very difficult words in Dutch, which are the Vrije Universiteit Brussel. Anyway, even though technically speaking for the moment I'm abroad, it only is a 2-hour or less than a 2-hour drive between Brussels and Luxembourg. And I think this more closely relates how both institutes, the Department of International and European Law of my university and the Max Planck really relate to each other. And this has much to do, I must say, with a person sitting here up front, that is Marco Benetar, who was my assistant at the Vrije Universiteit Brussel for a long time, 4 years that he stayed there. And when his funding reached the end, he then moved directly to the Max Planck Institute here in Luxembourg. This for me was an eye-opener because I was still supervising his PhD, and I still am. And this made me talk to him quite on a regular basis, and he kept on telling me how nice an environment it was over there in Luxembourg to do research, and how what good facilities they had, and also, and this is what I learned myself, also the very generous offer they make to foreign researchers wanting to stay here and do some research at the institute. So I must admit I have done quite a few of these 2-hour trips since then, coming here to do research. And this also explains why these two institutions for the moment are trying to organize also this conference that you are seeing here today. Thanks to the hard work of Tamar, who just left the room, Mitchell and also Marco, I think we now have and I was able to appreciate the hard work that they both did with the organization of today's conference. And this has been a very easy job for me because I watched it all from the back seat. But of course, we are here today with a very large audience and with, I would say, a very nice lineup of speakers, top-notch speakers on a conference which will deal with two aspects of water. On the one hand, the salt water, on the other hand, the fresh water. And you will not find that many conferences who try to make the link between fresh and salt water. Very often the legal principles which are applicable to both are different, but nevertheless sometimes they also try to converge. And I think that today and tomorrow we will try to learn how these two fields interact with one another. You might have been deceived by the weather. This is very exceptional that we have nice weather this late at the end of September in this part of Europe. But I trust you will not be deceived by the content of and the level of the discussions that will take place today and tomorrow. And with this, I would like to welcome you very warmly to this conference. And before doing that, I would now like to turn the floor to the people who are very important, of course, to make it all financially possible, and that is the Research Fund. Thank you.
Good morning, everyone. I'm talking in the name of the Fonds National de la Recherche in Luxembourg, and we are very pleased to have this opportunity to host, also co-found this kind of big conference. Because as a funding agency, we need also stakeholders. And just to promote Luxembourg a few moments, FNR, my funding agency, 1999, University of Luxembourg, 2003, Max Planck, 10 years later, 2012. So we are quite long in the field, and we are very happy to host such a big conference. I may use this opportunity also perhaps just to introduce you what we are doing in Luxembourg. This kind of conference are not so usual, and we really have the role of a traditional founding agency with multi-annual program. So think about it. We have also strategic program to foster international collaboration. And this is an example how we want things happen. For Universiteit of Brussel, just 2 hours away, but it's far enough. Just therefore, we are very pleased that it's worked and that it's attracting excellent keynote speakers and excellent researchers today. Perhaps you may also have a look at our web pages. We found different schemes. I will pass it today. But we want to increase, together with the Max Planck Institute, the visibility of Luxembourg. And therefore, thank you and wish you a nice conference.
Ladies and gentlemen, colleagues, friends, my name is Boldizsár Nagy. I'm the panel chair. And this is indeed a symbolic morning. Exactly 20 years ago, Peter Tomka and Samuel Wordsworth and myself were excitedly sitting in the Great Hall of Justice in The Hague, awaiting the judgment in the Gabčíkovo-Nagymaros project case. And almost 25 years ago, the second largest river of Europe was diverted by Czechoslovakia. So there's a lot to remember. But here we convened to review the lessons, and not only of this, but also of other cases. Have they advanced international environmental law? Have they advanced international water law? And many other branches of international law of treaties, law of responsibility. Of course, it would be fun to reenact the case, but we don't do that. I will assume my role as a panel chair and will resist the temptation to speak on behalf of Hungary, especially since 2010 I'm not involved in the bilateral negotiations. Let me only mention that this summer, Slovakia suggested the court to discontinue the case for a renewed judgment in there, and Hungary kindly agreed to it. As I said, this panel is broader than discussing the Gabčíkovo-Nagymaros case's lessons. We have 3 excellent speakers, and I will introduce them in the sequence as they will speak before they speak. So now I start with Samuel Wordsworth. He will address us with a talk entitled When and When Do States Choose to Litigate Transboundary Freshwater Disputes? I mean, he's an eminent professor of the King's College London, and he has participated in a great number, and he's participating at present also, a great number of freshwater-related cases, including the Gabčíkovo-Nagymaros case, the Kisenganga case, the certain activities and construction of the road cases, and the Silala case as well. Samuel, you have the floor.
Boldizsár, thank you very much indeed. And it's customary to start off by thanking the conference organisers for inviting one. And my thanks are particularly heartfelt because I'm able to give an entirely accurate and comprehensive answer to the question I've been asked to address. That is, why and when states choose to litigate their transboundary freshwater disputes in just 2 words. That is to say, it depends. And I can then pass on the microphone with further thanks to the conference organisers and indeed the funders for paying the airfare to Luxembourg. And if that's not quite enough, another response to the why and when do states litigate question could be given in 5 or 6 words. After all, they didn't pay for a business fare. And those would be along the lines of, well, on the whole, they don't. We'll be hearing later today about some of the many disputes out there that have not resulted in claims before some forum for binding dispute settlement. And the Gabčíkovo-Nagymaros case has not, of course, set a trend in terms of states proactively agreeing to resolve their disputes by special agreement. A general rule remains in robust health on this 20th anniversary of Gabčíkovo. If respondent states don't have to litigate their freshwater disputes, then generally they don't. And there's no surprise there. The prevailing trend more generally shows states preferring to avoid compulsory dispute resolution wherever they can, as reflected most obviously in the dispute settlement provisions of the treaties they sign up to. One notes that less than a handful of states have signed up to compulsory dispute settlement under the opt-in declaration provisions of the Espoo Convention or under the similar provisions in the Convention on Transboundary Watercourses and on non-navigational uses. And one might likewise think of the short and lonely existence of the ICJ's Chamber for Environmental Matters. So this is a very different world to the world of UNCLOS and Part 15 that we're going to be looking at tomorrow. And it's notable that the sources of jurisdiction since Gabčíkovo-Nagymaros have been disparate and venerable. So for the navigational rights and road cases between Costa Rica and Nicaragua, one sees invocation of long-standing optional declarations under Article 36 and also the 1948 Pact of Bogotá. For the Kishinganga and Pulp Mills cases, one sees one-off bilateral treaties establishing very important but discrete regimes. That is the 1960 Indus Waters Treaty and the 1975 Statute of Uruguay. And then most recently in the Salala case, the Pact of Bogotá is again invoked, this time by Chile in its claim against Bolivia. So while the Gabčíkovo-Nagymaros case shows the system working, shows how an issue of acute political sensitivity can be insulated and resolved so that neighbouring states have some space to seek to get on with their day-to-day bilateral relations, the reality is nonetheless that part of the answer to the why and when question is indeed going to be, well, really not that often, because of the lack of the consent from the respondent state. So bearing all that in mind, a third attempt at an answer to the why and when do states choose to litigate a freshwater dispute question would be because the state is, one, a downstream state, and two, because it can. That is, through some quirk of history, it's able to invoke some source of compulsory jurisdiction. But in fact, the Gabčíkovo-Nagymaros case doesn't fit so well within that answer, and it also fails to take into account the rather more erudite work on why states litigate that Natalie Klein has been pulling together over the past years. In one of her pieces, she notes that a number of potential relevant factors come into play, including economic considerations, historical considerations, the nature and intensity of domestic public interest, scientific and other evidential uncertainties, calculations of national interest, and finally, the character of the relevant legal norms. And those are obviously all very important factors. But because I unfortunately can't just repeat what Natalie has said in her writings, today I want to offer up the thought that the why and the when question can be answered by pointing to three common phases in the decision-making process. That is, one, the crisis, two, the agony, and then finally, three, the decision. And of course, at all points, the state is trying to avoid the fourth stage or the fourth phase, which might be called regret or bitter regret, or why did we instruct such bullish counsel, or possibly how can I credibly say this is all the fault of the previous administration. Anyway, a few more words on these three phases. And as to the crisis phase, Gabčíkovo-Nagymaros provides an absolutely excellent example. So one saw that on the ground, Hungary had first abandoned the works in 1989, and then it had purported to terminate the 1977 treaty between the parties. And Czechoslovakia was confronted with the difficulty of what to do with this vast and very costly infrastructure project on its territory, as to which it was being said, without fair support from Czechoslovakia's perspective, that an environmental catastrophe was in the making. At the level of bilateral diplomacy, the states had been actively engaged from 1989, when Hungary first acted to suspend the works, but those negotiations were leading nowhere, and of course Hungary had then gone on to suspend performance under the treaty and actually to purport to terminate. At the regional level, the EC Commission had become very closely involved in trying to resolve the dispute, but everything was suddenly coming to a head in the October of 1992, with Hungary seeking to seize the ICJ on 23rd of October, and then the actual damming works commencing the next day, 24th October. So a true crisis developing on one of Europe's great rivers, against the backdrop of former Eastern Bloc states wishing to become part of the EC, and against claims of environmental catastrophe. Hungary's attempt then to seek to seize the court is scarcely surprising. Czechoslovakia's willingness to respond in a constructive way and to agree to bring the dispute before the court is rather more remarkable. But there one should point to three factors. First, of course, the international pressure that was being placed on Czechoslovakia, but then also to the backdrop of the 1977 treaty, as to which Czechoslovakia, and that is Slovakia from 1st January 1993, considered that its position was very strong so far as concerns the purported termination. And then there is also the wish that one can perhaps see on the part of Czechoslovakia to play some role in the framing of the dispute, such that the dispute should not be limited to the issue of the diversion of the Danube, but that it should encompass the legality of the original suspension and abandonment of works, and then the purported termination. And one sees similar, if perhaps less dramatic, crises behind all the other cases that have made it to some form of compulsory dispute settlement. And that's not surprising, as even a downstream state has to confront various levels of political uncertainty and possibly a very real unwillingness to take responsibility for the decision to bring a claim that may ultimately leave the state worse off through being out of pocket and possibly having an adverse legal position entrenched against it. So looking at the Baglahar case, the crisis was looming because India's dam was fast being built, and so Pakistan had recourse to the neutral expert procedure under the 1960 Indus Waters Treaty. There's obviously a risk in leaving matters too late, and an expert or a tribunal having to rule upon a fait accompli. And notably, Pakistan commenced the 2010 Kishan-Ganga arbitration claim before any damming works had taken place on the river. But that was still against the backdrop of nearly 30 years of increasingly futile bilateral exchanges, and in circumstances where India was getting ever closer to the actual damming, a diversion tunnel was being built for the waters, and Pakistan itself was well advanced with a downstream project as to which there would be serious adverse impacts if India's works went ahead. And all this was taking place on a system of waters of existential importance to both states, and against the backdrop of the acute political sensitivities of anything occurring in the Kashmir region. So one expects to see the crisis, but then there is also the agony. And states don't say, well, we are the downstream state or a fellow riparian, we risk serious impacts through diversion or pollution, so let's just give it a go. Looking back on one particular case, I checked out and saw that the advices go into almost double figures across a 5-year period before the state in question commenced proceedings. Hundreds of pages of legal advice going to the questions of what the precise legal strengths of individual arguments are, what the strength of the evidence is, and how best to improve and present that evidence, to understand all the nuances of procedure and to work out who would be best to appoint as an ad hoc judge or an arbitrator. And so states, of course, they want to know, so far as they can, all the possible levels of risk that they face. And all that, of course, is entirely as one would expect, as people's jobs and reputations may well be on the line. Now, the task has perhaps got a little bit easier in the 20 years since Gabčíkovo-Nagymaros, because certain of the principles of customary international law are more readily identifiable as such, and also because, subject to what Judge Tomka will be saying shortly, it looks to me that courts and tribunals have become more predictable as to how they'll approach the disputed issues of fact, and more directive as to how they'll approach disputed factual and expert evidence. Gone are the bad old days of shadow experts behind the scenes providing input to the ICJ, and more international courts and tribunals seem to be open to the idea that expert evidence may all look rather wonderful on paper, but when it actually comes to the hearing, it's useful to test that evidence through cross-examination, and suddenly it becomes clear that some experts are good and some are bad, and some one really doesn't want to rely on at all. Anyway, the agony phase then feeds into the final stage of decision-making, but probably more as a sine qua non than as the decisive factor, because some foreign minister or president is going to have to be persuaded that litigation makes political sense from a domestic and, of course, an international point of view. So one sees, for example, from pulp mills, how a wide variety of factors can be brought into play. First, domestic pressure from the Argentinian inhabitants and the municipality on the opposite shore of the river to the planned pulp mills. Also, the risk of a precedent being set. Here, the risk of Uruguayan authorizations bypassing the procedure in the 1975 statute in circumstances where further mills were envisaged and indeed being authorized. And also one sees the failure of attempts at a negotiated solution. And similar factors appear to have been in play in Baglihar and Kishinganga, including as to the precedent factor, Indian announcements of multiple upstream projects in Indian-administered Kashmir in that case. And an additional and common enough factor when one gets to the decision-making phase, which one saw in Kishinganga, also appears to have been the need to have a forum in place before which a provisional measures application could be brought as and when the need arose. Curiously, in the two most recent freshwater disputes to come before the ICJ, the commencement or threat of other proceedings before the court appears to have played an important part in the decision to litigate. As to the road case, with the allegations of environmental impacts caused by Costa Rica to the Rio San Juan, it's tempting to think that this was part of a tactical claim brought in response to the strength of Costa Rica's claims in the certain activities case, with the hopes that the court might see both states as involved in multiple breaches of international law, that the court might take a plague on both your houses type approach. But that does not appear to be how the modern court responds to cases, and it's perfectly capable of disassociating the different legal issues and deciding them in accordance with their own merits. More recently, in the Salala case, there's a very unusual factor in that the upstream state, Bolivia, had announced in March 2016 that Chile was stealing its waters and that it was going to bring proceedings before the ICJ, but not before 2 years. And that was evidently too much for Chile, which appears to have seen it as critical to resolve the dispute without such a seemingly arbitrary delay and without unnecessarily prolonging the tension between the two states as to use of the Salala. So one final and more general thought on which to conclude. Vaughan Lowe, in a 2012 paper, made the observation that an international lawyer walks away at the end of a case, but the states concerned generally have to continue the business of getting on with each other in one way or another. And he makes this point in questioning whether international adjudication is necessarily so positive as often thought. And whether that is right or wrong, I suspect that the serious point behind Lowe's observation has played a role in the decision-making processes of all the cases that I've just touched on, in particular perhaps the Gabčíkovo-Nagymaros case, given that we are looking at a very special but dynamic, demanding dynamic of sharing parts of an international watercourse. Thank you very much. Thank you.
Excellently done, and of course it's very tempting to contribute to the narrative, but I will resist. And instead of that, I introduce to you Cesare Romano, professor, who is professor at the Loyola Marymount University, and he will offer us a perspective on the Gabčíkovo-Nagymaros case, whether it's much ado about nothing or not. He's well known as a founder of the Project on International Courts and Tribunals together with NYU and University College of London. He is a very prolific writer. I realize you have published 8 books, among them the Oxford Handbook of International Adjudication and the International Judge, an introduction to the men and women who decide the world's cases, and the peaceful settlement of international disputes, a pragmatic approach. So, is it much ado about nothing? Cesare, the floor is yours.
Thank you very much. I understand I have 20 minutes, so I will try also to be shorter than that, especially because I'm not sure what I'm doing here, considering that we have a judge of the International Court of Justice, 2 persons who litigated the case, someone who just summarized everything, so I really don't know what you expect from me. But in the next 19 minutes and 30 seconds or so, I will try to make some good use of that. Of course, thank you very much to the organizers for having me here, all the way from California. I was here in Europe only 10 days ago, so it was always nice to be back. So, as it was said at the beginning, today, to this very day, is the 20th anniversary of the decision of the International Court of Justice in the Gabčíkovo-Nagymaros case. So this is a good moment to engage in the pitiless exercise of judgment in hindsight of what the judges of the International Court of Justice did back then. Of course, it's never fair to judge things 20 years afterwards in the light of what we know now. So I would like, in a little bit of a kind of exercise, to bring back everyone 20 years ago. I know that it sounds like it was yesterday, but already 20 years ago have gone by. And we need to remember what was the context back then. The context was 2 countries that were satellites of the Soviet Union during the Cold War, who decided jointly to develop a shared water course, the Danube, and to enter into a treaty to that end, which was in 1977, for the management of the Danube, with the goal of producing hydroelectric power, enhancing navigability, better management to reduce fluctuations during the year due to seasonal events, and overarching trying to do that with an aim of protecting the environment. During the 1980s, when the countries then needed to start actually implementing the project, which entailed the construction essentially of 2 waterworks, one on the Slovakian side, Czechoslovakian, because at that time it was still a Czechoslovakia, and the other one at the Hungarian side of the river. As the countries started looking into that matter, the question became a lightning rod, especially in Hungary, which is a downstream state, because the population started being concerned about the potential of the impact on the environment, and especially on the water quality and quantity of the Danube in Hungary. An opposition movement started taking shape, but this being the Cold War, of course, the opposition movement became vocal. This became a point of accusation against the communist government for the way in which the country at large was managed. As we know, in end of 1980s, beginning of 1990s, communism collapsed. Both Czechoslovakia and Hungary became again free and not anymore ruled by communist parties. And therefore, all of a sudden, we had a transition whereby before, two communist countries litigating a case before the International Court of Justice was not an option, was not imaginable because of the doctrine within the bloc. But all of a sudden, it became a possibility and eventually a reality. So the issue was seen mostly on the Slovakian side as a question of independence. So the building of the waterworks in Slovakia was a statement of their independence. It was a technical issue leading potentially to greater energetic independence of the country. On the Hungarian side, on the other side, it became a matter of rejection of the communist past, the communists that had entered into the 1977 treaty, an expression of environmental concerns, and which was strong and supported especially by the agrarian movement. So not to get into the details of the dispute, but as we heard, eventually the two countries in 1993, under intense international pressure, decided to jointly bring the case before the International Court of Justice. Again, it's important to remember what was the context. During those years, there was a war in Yugoslavia. Therefore, no one wanted to have any issue going on to the northern part of the region. Second, both countries were eyeing the possibility of eventually joining the European communities, and therefore needed to make a show, at least, of being able to work out their disagreements in a European fashion and peacefully. The case was brought by joint agreement before the ICJ. Three questions were asked. One question, does Hungary have the right to suspend the works on its side? Two, has Slovakia the right to implement what will eventually be known as the Variant C, which was a unilateral work on its side of the border to divert the river? And three, what were the consequences, the legal consequences of Hungary's withdrawal from the 1977 treaty? So as we know, on September 25, 1997, the International Court of Justice rendered its decision on the merits. And essentially, it was a Solomonic decision. That is to say, the International Court of Justice told Hungary, no, you could not stop your works and carrying out your obligations under the 1977 treaty. It told Slovakia, well, you had the right to build the Variant C, but at the same time, you had no right to put it in operation. And then it told both parties, and now you have to figure it out and sit down and draft an agreement in good faith to settle this matter. And as far as responsibility is concerned, the court found that Hungary owed compensation to Slovakia, and Slovakia owed compensation to Hungary. So it was a purely complete Solomonic decision. Now, 20 years afterwards, yesterday night, I was thinking about today, I was thinking, like, what does the Gabčíkovo-Nagymaros dispute remind me of? And what came to my mind is some old James Bond movies, especially the one with Sean Connery. Okay, so they are very classic, but at the same time, they're very dated. So when you watch them, you see those weird things with lasers and technology that is so dated. So to me, the Gabčíkovo-Nagymaros case is exactly like one of those movies. That is to say, that has become a locus classicus in scholarly discussions of international environmental law and water courses. It's something that you cannot mention, but at the same time, it fell short in so many ways of delivering what could have been delivered. Let's start. First of all, what was the purpose of the whole exercise? On the face of it, the purpose of the exercise was to settle a dispute between states. This is indeed what the statute of the International Court of Justice says that the ICJ should do, right? So let's judge it by that standard. Did the ICJ settle the dispute? Well, in a way, yes, and in another way, no. No, because the countries were not able eventually to sit down and manage to come to that famous agreement that the ICJ told them that they had to reach. Right? An agreement was negotiated in 1998, but it failed to be ratified by the Hungarian parliament when it came for vote there. since then, no agreement has been reached. There has been moments now and again where the dispute looked like it was about to flare up, but let's say that over the last 20 years, the dispute has gradually lost of meaning and significance. And why is that? Because essentially the Slovaks got what they wanted. So they got the energy, the hydroelectric power that they wanted to have when they started doing the project in the 1970s. On the other hand, the Hungarians can have a claim of having won the case before the ICJ, because at the end of the day, they didn't have to build the dam that they had to build under the 1977 treaty. So it was a win-win, and it was something that politicians on either side of the border wanted to reactivate again. One of the reasons why we remember the Gabčíkovo-Nagymaros case, it was a herald of many things to come. At that time, it was probably the largest, in terms of number of attorneys involved, length of pleadings, case ever litigated before the International Court of Justice. They were like the who is who of international law appearing before the International Court of Justice. They even had the first visit on the spot, where the judges were flown into the region to look at the aquifer. I don't know how they did it, but seemingly they had X-ray vision underground. And the pleadings are a massive 25 volumes that occupy half of a shelf of any good international legal scholar. So the magnitude of the litigation was just heralding the trend that we will see in the future of over-litigating cases before the International Court of Justice. 1997, the year in which the International Court of Justice... by the way, how many minutes do I have to go? I'm trying to time myself.
You have 10 more minutes.
10 more minutes, right. So 1997, which is the year when the International Court of Justice rendered the decision, is also the year in which the United Nations adopted the Convention on the Non-Navigational Uses of International Watercourses. The 1990s was the golden age of international environmental law, right? We were still in the wake of the 1992 Rio Convention. There was a lot of hope and expectation about the ICJ using this case to finally spell out and advance some very, very fundamental principles of international environmental law. Now, did the ICJ deliver? Not quite. In typical ICJ fashion, they just stayed very conservative. They stayed close to very well-known ground. So most of the Gabčíkovo-Nagymaros case is about law of the treaties, the principle of pacta sunt servanda, most of all. It was about state succession, the whole question of the responsibility of Slovakia that inherited from Czechoslovakia. When it comes to international environmental law, the International Court of Justice, yes, it mentioned the principle of equitable utilization of water resources, and especially it used that to tell the parties this is something that you have to keep at the forefront of your considerations as you go out and negotiate the new agreement. There has been mention of sustainable development, but most of the discussion of sustainable development in the Gabčíkovo-Nagymaros case is in dissenting or separate, I don't remember, opinion of Justice Viramantri, not in the holding of the majority. Huh? It was separate, right, separate. Right. But other than that, there was not much of it in the main, in the body of the judgment. So the International Court of Justice sidestepped things that at that time were very important, which was elaborating a little bit more on the obligations that countries have to notify and consult with each other when there is works that are going to have transboundary impact. It didn't get into the details of the questions of international environmental impact assessment, and of course, it didn't elaborate on the precautionary principle. However, it was a first, right? And you need to start somewhere. So that is why we still talk about the Gabčíkovo-Nagymaros case after 20 years. It was the first time that the International Court of Justice tackled these things. And as we have heard before, then it was not going to be the last time There has been a number of cases afterwards, notably the most important of which probably is the Argentina-Uruguay, where the International Court of Justice finally had the chance to come back to that and further elaborate on those points. So in a certain sense, the Gabčíkovo-Nagymaros case was the first modern international environmental dispute litigated before the ICJ. It was also the first case litigated between two former satellites of the Soviet Union, and in itself, it proved to be a challenge, but also an opportunity. We could also say that, well, maybe the International Court of Justice didn't settle it, but at the same time, things could have got worse. So after all, it didn't blow up, and that is something to say about the whole process. As it was mentioned before, Slovakia, 2 months ago, withdrew the request that they made in 1998 for a second judgment in the case. The fact that this was withdrawn by Slovakia and the withdrawal was accepted by Hungary signifies that for all practical purposes and intent, either the two countries have completely given up on the ICJ, or the two countries believe that actually the dispute is no longer an active dispute, and therefore they are ready to move on and move beyond that. So in either case, unless there are some dramatic developments and events in the near future, we can simply say that the Gabčíkovo-Nagymaros case at this point is a page for the history of international law. A very interesting one that we need to go back, but as I said, as Goldfinger is very much dated. All right, thank you very much.
As you can imagine, your chair of the panel now feels like Prometheus when he was chained to the rocks and couldn't act. Of course, I would be happy to contribute to the narrative, maybe from a different angle, but I won't do that. Instead of that, I have the pleasure to remind you that we have the eminent speaker. Most of you, probably all of you, know Judge Peter Tomka. Peter Tomka has been sitting on the judge since 2003, and at the same time, he's an eminent scholar. Within the court, he was vice president and then president of the court for altogether 6 years. He's well known in all these circles. And with his kind permission, I will introduce his talk, which is about the technical and scientific evidence in freshwater disputes, with a quote from another person who was acting on behalf of Slovakia in the Gabčíkovo-Nagymaros case, Alain Pelé. And this is what Alain Pelé wrote in a 2008 article, which will sort of induce Peter Tomka's talk. When technical questions are discussed, in particular concerning cases related to the environmental protection, it seems to me that the files constituted by the parties are abusively technical and abstruse, or in any case, incomprehensible for normally constituted jurists who have only limited training in chemistry, geology, or hydrographics. That's from an article on international courts and tribunals in 2008. So, how do judges deal with technical evidence? Peter, the floor is yours.
Thank you very much for having invited me here on this occasion. 20 years ago, I entered the Great Hall of Justice a little bit nervous, and then I had to listen for almost 3 hours reading of the judgment by President Schwebel. Well, I was not sure whether to believe what the press in the capital of our southern neighbor reported a few days earlier or not. But at least this newspaper report contributed that I had a rather quiet night before the delivery of a judgment. And at the end, I was quite pleased when President Schwebel completed his reading. I have to confess that now I'm a little bit even more nervous because I have been presented not only as a judge, but also as a scholar. Well, I had ambition when I was young to become professor of international law. I taught at Charles University Law School, an old university established sometime in 1348 by emperor who had some roots in this country, Charles IV, the son of Jean de Luxembourg. But I felt myself as assistant in surgery who never did any surgery, not even assisted. So I wished to have a practice in international law. And in a small country where you can practice international law, the best way is International Legal Department of Foreign Ministry. And then in 1991, I was sent to New York as legal advisor to the Czechoslovak mission. And it's, again, the best position for a young international lawyer who would like to get practical experience from public international law, because it's there where texts are negotiated, commission of the work of the International Law Commission discussed, etc. And it was there when, with my friend Mikulka, Václav Mikulka, who was member of the International Law Commission in 1992, in October, we received a message that Hungarian diplomats submitted to the court the application signed by Minister without portfolio, Professor of Private International Law, Mardul Ferenc, bringing a dispute to the court about the diversion of the Danube water and inviting Czechoslovakia to accept jurisdiction under Article 38, Paragraph 5 of the Rules of Court. Hungary, a day before, made a declaration. So thanks to the Gabčíkovo-Nagymaros, we have now Hungarian Declaration recognizing jurisdiction of the court, which is still in force since 1992, 22nd of October. And as it was said, the press, and you should remember that 1992 was the year of the Rio Conference and big statements about environment and sustainable development, and this project was presented as a socialist megalomania. We had some problems to accept that idea because in Germany and Austria you have more than 20 dam projects on the Danube. And here, in the joint sector between Czechoslovakia and Hungary, where the river constitutes a boundary, there was one dam to be built, a big one certainly, but just one. And the other dam was to be built in Hungarian territory, in Nagymaros, where the river is not anymore boundary river. So EC was involved. So from New York, we advised foreign minister, who was a Slovak, in the government, the main task of which was to dissolve the federation. So the government consisted of 10 members, 5 Czechs, 5 Slovaks. And under pressure, the government wished to issue the order, stop the damming of the Danube. All 5 Czech ministers voted in favor, but all 5 Slovaks voted against. So no decision was adopted, and the construction went on. So we advised the minister that, okay, if Hungary would like to have a dispute before the court, this could be done, but not unilaterally and not in a limited scope, in all aspects of the case. So Czechoslovakia responded by inviting Hungary to start negotiations about the conclusion of a special agreement. And the negotiation started in late November. I supplied from New York some texts of special agreements from the past cases. In December, there was a second round, but then federation ceased to exist. And I had to pay dearly for my advice, because then, first day of independence, Slovakia received a phone call. You are recalled from mission in New York, we need you back home. I had to call foreign minister, well, that's not what I intended. But nevertheless, I complied with the instruction. I returned back. I completed with Hungarians the negotiation on special agreement, and the minister told me, well, you have accomplished your mission, return back to New York. And a few months later, they needed an agent, so this is how I became the agent in the case. But also the dissolution of federation led to the fact that I could not have completed my ambition to become professor of international law, despite the fact that my professor told me one day you are going to inherit this chair at Charles University. So I never returned back to academia, but my ship drifted away rather to legal practice. It's true that the Gabčíkovo-Nagymaros case is portrayed as an environmental case, but I think it's mostly to the fact that it was portrayed that way by the party which was more interested in litigating before the court, and that was certainly Hungary. Czechoslovakia, later on Slovakia, did not oppose, but we portrayed the case slightly differently, much more complex. And we insisted to put into the special agreement a number of other issues. I understand that James Crawford, who was lead counsel for Hungary, was then a little bit unhappy that he was not consulted when the negotiations took place about the special agreement. And certainly he was also a little bit disappointed that he was not consulted in May 1991 when Hungarian government invoked 5 grounds for unilateral termination of the 1977 treaty for the construction and joint operation of this project. So his hands were a little bit tied. He could not have invoked some other arguments for the unilateral termination of that treaty. So Slovakia tried to portray the case as the case about the treaty interpretation application, because there were also articles in the treaty of 1977 about the protection of the nature. Environment in 77, environmental law was not yet so widely used. But there was an article about the protection and obligation of both parties in relation to the protection of the nature. So, of course, there were scientific arguments presented by the parties. I do not know whether our partners needed some time to prepare these scientific arguments, but the fact, or whether it was a tactical move. But it's true that they filed the volume on scientific evidence only with a counter-memorial, not with the memorial. There was parallel filing of the pleadings by both parties. And then, in the meeting with the president of the court in December 1994, they insisted there should be only 4 months for the reply. Of course, we had problems with that because we needed to study the scientific evidence and to prepare the response to that. And moreover, we more relied on experts who had been working on the construction of the project for decades, 2 decades, even longer. But certainly they were not so fluent in English, so there was a need first to translate the pleading into Slovak language, while Hungary relied more on recognized experts, either from United Kingdom, Imperial College, or from Universiteit of Strasbourg, or some German experts on river morphology. But it seems to me that at the end, the court more relied on the treaty. And I think what was also of crucial importance was the fact that the judges decided, upon invitation of Slovakia, to exercise their powers and to proceed with on-site inspection. It was in June, 4 days before filing the final round of written pleadings, that Slovakia sent a letter to the court inviting it to exercise its powers, because we were not sure whether we would reach agreement easily with Hungary. But of course, it was difficult for the Hungarian agent to respond no. So the answer was more diplomatic, to the effect that if the court would find it useful to proceed to the site inspection, Hungarian government would be happy to cooperate. So it took us then almost a year, upon invitation of the court, to negotiate the protocol on site visit, which had been undertaken by the court in 1997 between first and second round. And I was pleased to hear from one president of the investment tribunal in Burlington case. It's not confidential, so presiding by Professor Kaufmann-Kohler and Professor Stern sitting as arbitrator and Stephen Dreimer. that this protocol was very useful and helpful for them when they prepared the order on site visit. In that case, when they traveled with carriage to the Amazonian rainforest in Ecuador to inspect the areas of alleged contamination by oil. That was not a river case, that was a case relating to oil exploration, exploitation, and then environmental damage caused, counterclaim quite substantive, $2.5 billion US. So at least this protocol was used for at least for one arbitral tribunal in organizing the site visit in that case. But I think it's time for me to turn more to the topic I was assigned, and this is about the scientific and technical evidence in selected cases, because it's true that the issue of scientific and technical evidence before international courts has, in recent years, received considerable academic attention. And the ICJ is no stranger to dealing with intricate questions of fact involving complex scientific and technical aspects, including in the context of transboundary freshwater disputes. The question thus arises, what is the best way for the court to obtain the scientific or to treat the scientific and technical evidence that is necessary for it to render judgment in these kind of cases? Already I mentioned that site visit is one of the options. The court proceeded that way in the Gabčíkovo-Nagymaros project case. For your information, arbitral tribunal in Kishangaga case between Pakistan and India was invited by Pakistan to go twice on site inspection, one in summer when snow in the lower altitudes of the Himalayas is usually melting. And the full court proceeded to that visit, 7 members court, 6 lawyers and 1 engineer, because that's the requirement of the Annex G to the Indus Waters Treaty. Well, in winter, as this was a little bit riskier, well, we delegated just to use the terminology of the Indus Waters Treaty, umpires. That means not party-appointed arbitrators, but those either agreed jointly, but you can imagine Pakistan and India agreeing on somebody, almost impossible task. It's out of record here. So the appointing authorities under the Indus Waters Treaty appointed the umpires. So Sir Franklin Berman, appointed by Chief Justice of England and Wales, who was drawn up as appointing authority because the other option was Chief Justice of the United States Supreme Court. And then Howard Beater, Professor of Hydrology, originally Imperial College of London, but now at University of Saskatchewan as eminent scholar, appointed by Rector of the Imperial College. The other appointing authority could have been President of the Massachusetts Institute of Technology. They traveled in February to the area again and provided some video recording with the assistance of brave young registry members of the Permanent Court of Arbitration. So other arbitral tribunal members had the opportunity to familiarize themselves also with the conditions in the winter period when there is a low discharge of water in Kishenganga River, which when it crosses the boundary becomes Nilum River, each party calling it by a different name. Well, I can also disclose that at a certain moment, in a case which is currently under deliberation, I have to be very cautious what I say, because counsel of both parties are sitting in the room. We joined 2 cases, land boundary in the northern part of Isla Portillos and the maritime delimitation when we, for the first time in history of the court, have to determine maritime boundary not only in the Pacific but also in the Caribbean. And so this is more topical for Caribbean. We face the problems that both parties differed in describing the status of the coast in the Caribbean, and they put the starting point for the maritime boundary in different places. Well, you may think that the difference of some 3.6 kilometers is negligible, but when you have 200 nautical miles maritime projection, it's already quite interesting chunk of the maritime space. So one of the options was site inspection, but I can understand that some of my colleagues did not consider that as the most pleasant area to be visited, because this is in the area of protected wetlands. So the court opted for a different way of obtaining evidence, and which is allowed under the rules of court. And we appointed experts in that case. 2 experts who traveled to the area, first in December and second in March, and produced a report. And the parties had the opportunity to comment on the report. And I think that report was useful in clarifying for members of the court the situation. Of course, I cannot go any more further, and you will learn most likely early next year what was the impact of that report, combined with certainly skillful arguments by agents and advocates on the final resolution of the dispute by the court. Well, the court was also presented with enormous amount of scientific evidence in pulp mills case, which by coincidence fell on my shoulders because President of WADA was sick. We had to deal with arguments in Argentina that once these 2 pulp mills in Uruguay are put into operation, there will be a substantial increase of non-infernals in the waters of Uruguay River. You may have noticed an opinion by 2 members of the court who wrote about expert fantôme. Well, it was a little bit painful for me to read. We discussed that matter in the course of the hearings, but some members, including the authors, took the view that it may have been a little bit too late to appoint experts in that case. And in fact, there were no phantom experts, I'll tell you. There were experts on this science available for members of the court for individual consultation. They were never invited to the deliberation room. They never expressed the views to the full court. So I call them walking encyclopedia. Instead of looking in the encyclopedia to explain what is an non-infernal and what are the impacts, etc., and I can't even remember all these chemical substances referred to in the pleadings, judge who had difficulty to understand that had the opportunity to consult that expert. But it was for the judge to form his view and the repercussions of that for legal issues. It's like in maritime delimitations. Don't think that judges are calculating coordinates. The judges are producing, or registry staff, the maps. No. ICJ and ITLOS, I think that those who participated in ITLOS as ad hoc judges would confirm to me that the courts rely on cartographic experts once the court determines and describes orally what should be the course of the maritime boundary to calculate the precise geographical coordinates. Judges cannot claim they are experts in calculating geographical coordinates. So there were no phantom experts in that case, and certainly they have not influenced the impact of the case. But the pulp mill case was an interesting one, because in that case we sent a mildly worded advice to future litigants before the court, because the court said both parties had experts who appeared as counsel. they advocated the position of one or the other party. They have not acted as independent counsel, and they were not subject to cross-examination. So the court said something along these lines. The court found the presentation of evidence by experts acting as counsel of the parties unhelpful, and considered that those persons who provide evidence before the court based on their scientific and technical knowledge and on their personal experience should testify before the court as experts, witnesses, or in some cases in both capacities, rather than counsel, so that they may be submitted to questioning by the other party as well as by the court. End of quotation. And in subsequent cases, the parties appear to have taken the court's remarks to heart. In the whaling case between Australia and Japan, the court benefited from hearing of experts from both sides who were cross-examined and responded to questions put to them by the court. And the court followed the same procedure in the joint cases concerning certain activities carried out by Nicaragua in the border area and construction of a road in Costa Rica along the San Juan River. What may be also useful for the court, in particular in cases involving the scientific and technical evidence, is to organize what is contemplated by the resolution concerning the internal judicial practice of the court as Article 1 deliberation, because it's regulated by Article 1 of this resolution. And it provides something to the effect that ahead of the oral hearing, the court may meet and exchange views on certain aspects of the case, and in accordance also with what is in the rules of the court, direct the parties which issues the court would like to have addressed more in detail. So we had, this was a dead letter for several decades, but that's not a river case, but still environmental case, area herbicide spraying case between Ecuador and Colombia. We had this deliberation, Article 1, and then we sent a list of issues to both parties the court would like to have addressed. And just less than 3 weeks before the planned hearing in September 2013, we received a letter from the parties that they settled the case, and they, in the joint letter, said that it would have been difficult, if not impossible, for the parties to settle without the court's involvement in the case. And certainly, the court was not unhappy that the matter was settled, and it was settled to the satisfaction of both parties, because Colombia could have continued with spraying, destroying the coca plantations of FARC rebel movement, but under much stricter conditions, establishing a buffer zone, flying the planes in lower altitudes, monitoring, and then after 2 years monitoring, adjusting if necessary the rules. And also Colombia, without accepting international responsibility, agreeing to pay some $15 million for social economic development of 2 border provinces in Ecuador. And perhaps I can disclose that we had also Article 1 deliberation in the whaling case. That means we prepared well for the hearing in that case. So you see, there are provisions in the code which allow the code to deal with scientific and technical evidence, but of course the parties should not transform a legal dispute into a dispute between scientists, because as Professor Pelle said, it might not be easy for judges to act as experts on all these technical matters, and on the other side, judge should not be tempted to delegate his responsibility and to have the matter decided by scientists. That's not their role. Their role is just to advise members of the court or judges ad hoc, and then on the basis of proper analysis of the case file for the court to come to the outcome. I know that I have already surpassed my time, but as Gabčíkovo-Nagymaros case was mentioned, I would just add that because there is some question why the case has been still on the docket for so many years. In 1997, 25th of September, judgment was rendered. In October, delegation started to negotiate. By February 1998, there was a framework agreement, text of the framework agreement on the principles for the implementation of the judgment agreed. And imagine that framework agreement contemplated to build a dam in Hungary. Not just to keep Gabčíkovo dam and power station running, but also to build the second dam. And the second dam was important if Gabčíkovo was to be operated in the peak mode regime. That means accumulating the water in the reservoir and releasing the water when there is a high demand for electricity and shutting down the turbines in the night because there is no so much consumption. And there were only two alternatives for the dam in Hungary. Either Nagymaros, as originally, or Pilismárod, a few kilometers upstream. There was already a date agreed on for the signing of that framework agreement in London, 10th of March 1998, because prime ministers would go there and Tony Blair would praise them for their wisdom. You know, it's also important to sell the agreement to the public. But the Hungarian prime minister had problems because a junior coalition partner, Liberals, 3 months before election, threatened, if you sign, Prime Minister Horn, we would quit the government. So Prime Minister Horn wished to calm the situation and to take a risk before the elections. So the government decided not to reject the framework agreement, but once more, because that was similar in 1989, the government said, well, we need some scientific studies to substantiate the two solutions and to see which one is better. And that would require work for scientists until, and this brings me to the topic I was about to address, to the end of 1998. But Prime Minister Horn, socialist, lost badly elections in May 1998. It was the first time when Viktor Orbán came to power. And in July government program, they dismissed the text of the framework agreement that it's non-starter. So Slovakia's prime minister, Mečiar, was also facing election, so he wished to show the population that he is defending the interests of the country. So he ordered, go back to The Hague. He already in March started to instruct lawyers, go back to The Hague, because under the special agreement in Article 5, if the agreement is not reached within 6 months, either party may ask the court to render additional judgment on the modalities for the implementation of the judgment. Lawyers waited a little bit because they had nothing to cook from. But once the government program was approved in Hungary, there was an argument. So on 3rd of September 1998, we filed Slovakia. I should a little bit depersonalize myself, as I have assumed different role. Application requesting the court to render additional judgment. But that request is rather procedural, to set the deadlines by which the parties have to reach agreement that they should sign, negotiate and sign the framework agreement by a certain date on the principles of implementation, and then subsequent agreement on the implementation should be reached by a certain date. Of course, there was also a provision that Hungary should be held responsible for failure to reach agreement, but I'm not sure whether the court would have been comfortable with such a submission, but not to leave the other party empty-handed. So it was there. But in November 1999, after elections in also Slovakia, there was a change in government. The foreign ministers met and they agreed that they would resume negotiations. So the court was very happy that the parties resumed negotiations, and since then, so-called parties are negotiating until today, not very intensively. But I have to say that what is important, that in 1995, they signed an agreement on temporary water management regime and some technical measures. It's mentioned the conclusion of that as a task for the parties in the special agreement in the preamble and in Article 4, because Slovakia wished to avoid that there would be a request to the court determining the water management regime. Slovakia considered that this is a technical issue which is not suitable for the judges to determine water management regime. Judges are not experts on water management. So negotiations resume. There is a joint monitoring. Each and every year there is exchange of reports between appropriate authorities, environmental authorities, both in Hungary and Slovakia. And I think twice a year delegations meet, either in Budapest and Bratislava, for friendly talks. So it seems that the parties do not expect any action from the court. The past presidents, Higgins, Ovada, and Vice President Sepulveda, because certainly I'm not in the case, but my time, Sepulveda was Vice President, they invited once in 3 years' time the agents for consultations to ask them, what do you want from the court? And the answer was, at the moment, we are grateful for what the court has done, but we do not expect at the moment any action from the court. So we will see what is going to happen, and I apologize for crossing over slightly my time limit. Maybe I will be short in answering the questions. Thank you.
You are forgiven, of course, and I still resist the temptation to contribute to the description of what happened and what did not happen. But I'm available during today, so if you want to hear another view of the case, feel free to come up to me. Do we know whether it will be removed from the general list? Because that you are the most competent person to know.
I cannot say anything. I cannot say anything on this issue because I am not in the case, and it's for the plenary, or if the court is not sitting, it may be for the president. So let's wait, and you will see.
At waiting, we are good. Now, let me open the floor. I'm sure you have lots of questions, and we have ample time. We have 20 minutes for questions and answers. I do apologize. I may not know all of you, so I will not call you by name, but I will just point to you and say, please go ahead. I assume my mics are around, so you indicate with your hand that you want to contribute, and then questions are most welcome, comments are also welcome.
And could you as well?
I will start. Laurence Boisson-Chazon. Thank you for the 3 presentations. I'd like to ask a question to Sam. So, strategies. So now, would you consider that? What would you suggest in terms of pros if you were advising a state to go before the International Court of Justice? What would be the positive elements of going before the International Court of Justice? And with respect to the evidence to Judge Tomka, do you think that now the court has sort of settled its practice with respect to evidence in technical cases?
I think we should get the answers right away.
Well, it could be quite a long answer, so I'll cut it brief. But if you're thinking about going to the ICJ, there's a very good chance that you don't really have any choice. It's either the ICJ or nowhere. You're unlikely to be in the same sort of position as might conceivably arise under Protocol 15, where the parties can work towards a choice of forum that is more sort of flexible as to what they need. I think if you're thinking about the ICJ, the good things about it are obviously higher profile than an international arbitration. you know fairly well what you're going to get. I would say, as I intimated earlier, I think the approach of the court to evidence is much more well established than it was before. I do have a slight query even about the use of shadow phantom experts, as Judge Tomka has described it in the Pulp Mills case, because that does input into the judge's decision-making process if you're asking somebody on the side, even if it's just an individual judge. So it's not like the establishing geographical coordinates, which is at the very end of the judging process. So I would see a difference there. And I do think the untested evidence of an expert, cannot be quite as reliable as one thinks. And there can be an opportunity, perhaps instead of having such a resource for an individual judge, asking the parties and making it clear that if it is a semi-logistical matter, like what various chemicals mean or what their impacts are, then say you've got to go away and agree this.
Well, I don't know whether we have now a settled practice on dealing with scientific evidence, but I think what is clear is the tendency that the court is now much more proactive, willing to use options which are available, either appointing experts of the court, or if it's appropriate, proceed to site inspection, but of course, site inspections are not the touristic opportunities. But I think what is also important that the court addressed a kind of recommendation to states in the Pulp Mills judgment, and it seems that, as I said, the parties now proceed that way, that the technical experts or scientific experts do not appear as counsel arguing, but they are available for examination by the other side. This certainly helps then the court to form a view. But you may have different approaches to your role as a judge. Some judges perhaps have a tendency to think, well, which party or expert of which party is more convincing. Others try to get to the bottom of the things. And that was also what was visible inside when we had the deliberation how to deal with this different description of the coastline in the Caribbean. Some thought that, well, those who described it more convincingly. Others were of the view, no, we need really a solid information on which we can then base ourselves. And that view prevailed, at least in that case, but you never know, because that's also a lesson I have learned, that you cannot predict the outcome, and I would not be as optimistic as some Wordsworth QC. And of course, I'm not going to compete with PCA without the advantages and disadvantages of bringing dispute to the ICJ or the arbitration. It's for the parties to select. Sometimes you have no option, just to proceed one way. For instance, Kishenganga dispute. Both parties recognize jurisdiction under 36(2) of the statute, but one has to look at the limitations or reservations. But what is decisive is that in Indus Waters Treaty of 1960, there is a part on dispute settlement procedures, and that contemplates either independent expert or a court of arbitration. And in Kishenganga, there was court of arbitration. I'm not disclosing any secrets. There is a dispute again between Pakistan and India, which was brought to the attention of the World Bank. World Bank published a press release many months ago. Pakistan would like to arbitrate again and ask the World Bank president to act as appointing authority. But India opposes that. No, this matter is for independent experts. So India filed 2 weeks later a request for the appointment of independent expert. And the president of the World Bank, Dr. Kim, Doctor of Public Health, does not know what to do. Of course, he has a general counsel. So he postponed the procedure, inviting both parties to talk. They met twice, in July, in September. No result. And I understand that Pakistan is once more pushing the arbitration route. Well, we have to wait and see what is going to be the outcome.
Yeah, if I can just come back very briefly on some of the things Judge Tomka's introduced. The idea of what are the advantages or potential advantages of the PCA, I think it's important to emphasize that the coffee is much better. It's also worth pointing out, I'm always surprised that people aren't using the chambers of the ICJ more, because one has seen from cases like Gulf of Maine that the possibilities for shaping a chamber that looks very like an arbitral tribunal and that allows you to have the people you want deciding your dispute and for free. So I'd have thought there'd be a lot to be said for that. But if people want to avoid the possibility of enforcement through the Security Council and states don't like litigating generally, then they're likely to go for what might be seen as a softer option in arbitration. Judge Tomka's just mentioned the issues of whether decisions are going to be predictable or not from the ICJ. I would have thought by and large yes, but I hope perhaps somebody tomorrow is going to be talking a little bit about Peru and Chile, where you do see a decision coming out from left field, which to me at least I find quite difficult to sustain from a legal point of view.
Thank you.
Well, if I may add, just because there was a comment on the coffee served in the court, but it's a free coffee. You do not pay for it. For Nespresso provided in the PCA, at the end the parties are charged. And we are a very poor UN institution. Our budget is extremely limited, and hospitality is a small one. But we still offer a warm hospitality, because when the parties litigate the merits, not jurisdiction, because it's not polite when you challenge jurisdiction of the court, but when you litigate the merits of the case, at the end of the hearings, we invite both parties, the counsel, for a reception, and I think it's a decent reception, yeah.
Alan Boyle.
Yes, thank you very much, and thank you for a very interesting session this morning. It is, of course, 20 years since the Gabčíkovo case, and I'll turn this into a question, but you can probably work out what I think from the question. Professor Romano gave us a rather downbeat view of Gabčíkovo on international environmental law or international watercourse law. I'm afraid I rather disagree with the one on both points, but we've got two other panelists here who are very well qualified, I think, to offer their view on what they think 20 years later the significance of Gabčíkovo is for international environmental law and for international watercourses law. Thank you.
Thank you. I think it requires no comment. Next one. Questions, comments. Attila Tansi.
Thank you. Very short comment on a remark made by Sam that is very practical, very interesting. Why not referring to chambers of the ICJ when there the parties may have some control and can have a little bit of the best of both worlds, including the economic side to it. I, as a young advisor, was helping the negotiator with the United States in the Elsie case, but we opted for the chamber. There, the expertise was not so much an issue. But I remember that in the 90s, the ICJ, at some point, clarioned the setting up of an environmental kind of chamber, which has never been used and put to fruition. I think it has been discontinued. Whereas, apart from coffee, you may take note of the fact that you have a PCA separate list of arbitrators, possibly knowledgeable about environmental issues and natural resources issues, and that is another option that may be taken into consideration. Thank you for that.
If I may just offer my comment to this comment, because that wasn't the question. Certainly, there was an environmental chamber constituted in 1992. You know, the court, under the President Sir Robert Jennings, felt a need to respond to Rio Conference. So the court established this environmental chamber. But then the British President, Dame Higgins, when we elected committees and chambers in 2006, came to the conclusion, well, why to elect an environmental chamber? There was no use. And if the parties wish to have a chamber, they can agree. And about this advisability of constituting a chamber, let me tell you my own experience. In 1992, early February, I was in Budapest. The text was almost ready. And I suggested to my Hungarian partners, oh, well, and what about submitting the dispute to the chamber, not to the full court? And I had some names in mind. And they rejected that because they thought that it was a delaying tactic on my side, you know, because in principle we have to agree on the composition of the chamber. And when the judgment was rendered, I was so happy that that was not submitted to the chamber, because the outcome would not have been so convincing in terms of votes for Slovakia. So you see, you may have a famous name, but not necessarily then you would be happy with the legal view of that famous name. So I was happy that the case was brought to the full court.
I think Cesare wanted to contribute.
Yeah, I know. I just have a question for, so to speak, for Hungary and Slovakia. Do you think that the involvement of the ICJ in the case helped or did not? And if it helped, how?
A lot, because the high tensions were diffused. It ceased to be a political problem for, to use a neutral term, for people in Brussels, you know. They wish always to be involved, to be in control. And so it ceased to be the problem for them because it was sent to the International Court of Justice. It ceased to be a major theme for international press. So for Slovakia, that was a very good move. And at the end, we were very satisfied with the outcome. On all points, the court has given, has accepted Slovakia's position by majority votes, but frequently very strong majorities. We only lost one issue, but you know, I was desperate because I was not able to put immediately the question to these illustrious judges, asking them, imagine you have built a big project worth of billions of dollars. It was almost to be completed. You cannot let it idly because it will deteriorate. I accept your point that there should be a joint regime, but how you would put it jointly into operation when the other party, treaty partner, is not willing to cooperate? Yeah. So I think Slovakia has no other choice than just to put it into operation, because the project would have deteriorated not being put into operation, and large investment would have been wasted. And I think time has told us that it was appropriate, because no environmental disaster has happened. I'm not denying that there might be locally some issues to be addressed, but after 25 years since operation, the nature has not suffered enormously. We in Gabčíkovo have a sport facility, white water rafting facility. Thanks to that, we have won a couple of gold medals in the Summer Olympics. I mean, Slovakian sportsmen, athletes. And I'm not going to comment how the court interpreted in its judgment, not a concession, but a statement that if the joint environmental studies proved that there was a heightened risk of irreparable environmental damage, Slovakia would have been willing to agree on the abandonment of the peak mode operation. And the court from that drew the conclusion that Nagymaros project is not necessary. And as you said, the court then basically satisfied Slovakia, you have your dam, and satisfied Hungary, you do not need to construct the dam.
Well, Now the temptation is enormous, and I will again resist.
Please, give in to the temptation.
I will again resist it, because the answer to your question from my point of view, which is not the Hungarian government's point of view, I'm an individual professor at the moment. I'm not involved in the case. I'm no longer counsel for Hungary. The judgment had the potential to sort out the dispute. The dispute is still pending. The judgment essentially said there is no need to build a second dam. We are in agreement on that. And the judgment also said Gabčíkovo may operate if that can be done in an environmentally sound way. This is all what Hungary wanted, an environmentally sound hydropower station, if it is possible, and no ruining of the Danube band. So it was a success from both sides. But it has not been implemented. The judgment has not been implemented. We haven't found a way how to operate Gabčíkovo upon consent in an environmentally friendly way. That's not the fault of the court. It's not the fault of the judgment. The judgment had the potential to sort out the dispute. If it didn't happen, it was because of the parties. And that's also the good news. The same parties can find a solution if they really want. So Michael Wood.
Thank you. I wanted to ask about site visits and how useful they are, and to compare perhaps a maritime case with a river case. I can see if you go to see a river, you see something. If you go to see the sea, well, it's just a stretch of sea, largely. Though in the Bangladesh-India case, we did have a site visit, very complicated, quite dangerous. We had to have armed guards to keep the tigers away. I note that in the Philippines-China case, there wasn't a site visit. That would have also been interesting and perhaps actually quite useful. But just to compare, our site visit, I think, was, as far as I could see, not useful at all. It's hardly reflected in the award. We chose a time when there was a monsoon. Low water tide was at 6 a.m. and 6 p.m., so we didn't see anything because it was dark. Of the base points and low tide elevations. So just to learn, is it really useful, a site visit? It's certainly exciting. Thank you.
Maybe you should have planned it in a different period when there is more light in order to see something.
I mean, I would share the doubts as to how useful they're going to be in a maritime case. But it depends on what you're going to see. So you could see in the South China Sea case, there might have been real point to it. Because in the cases we've been talking about, that the point of the site visit in both Gabčíkovo-Nagymaros and in Kishinganga is that one side wants to show to the court or tribunal that there's a lot of concrete there, that a vast amount of money has already been spent. And so Slovakia is saying to the court, just as Pakistan was saying to the court in relation to its downstream project, for goodness sake, we've spent all this money, and whatever you do, you have to include that as a factor to work around. And I think that's one of the positive, or one of the actual impacts of Gabčíkovo, so far as concerns the tactics of cases going forward, is that claimant states have become very alive to the difficulties for a court of telling a state to undo a project that has cost hundreds of millions of dollars to put together. And that's why in the Kishinganga case, you see the provisional measures application being brought very early, before the damming had been stopped.
Of course, as someone who has accompanied the judges to that visit to Gabčíkovo-Nagymaros, I would have to add a lot, but I won't. Is there anyone of you who wants to contribute?
Not on the Gabčíkovo case, but you can also combine expert and site visit. And I think this happened in one PCA case. I was not involved in that, but in Guyana, Suriname, a maritime delimitation, there was the issue where to put marker number 1 and to locate it. And the tribunal decided to appoint an expert who, accompanied by senior registry staff member, or I do not know whether it was not Deputy Secretary General personally, traveled there with the expert, and that expert assisted the tribunal in Guyana, Suriname, to determine the starting point of the boundary. So I think this could have been, and certainly this, I think, was helpful for that tribunal. It depends on the circumstances. You know, when you have major disagreement between the parties about the starting point and uncle the situation. So, and if you do not wish to base your decision, who was more convincing? Yeah? Because again, you have different approaches based on your legal culture. Whether you are looking for objective truths or who is more convincing?
The good news is that we are going to have free coffee. But in exchange, the organizers decided that we might go on a little beyond the planned 11:15. Tulio Treves, you have the floor.
Thank you very much. I would like to make just two small observations drawn on my experience as a judge in the International Tribunal for the Law of the Sea. First, about these specialized chambers that have been mentioned. Of course, the court was the forerunner with its chamber on environmental issues. And the tribunal, not a long time later, followed setting up 3 chambers, if I remember well, on fisheries, on environmental matters, and on something else, later followed by a chamber on delimitation. I personally, is not a big secret, I never was very persuaded of the usefulness. To me, they are pure, on both in the court and the tribunal, propaganda exercises. They are a way for these adjudicating bodies to say to their clients, we are interested in these new fields, environment, fisheries, and so on. So please bring us cases on this. We have a specialized chamber. But of course, imagine in the Gabčíkovo case, if there had been a chamber for environmental matters, would Slovakia ever have accepted to label the issue as an environmental one? Certainly not. So this shows how these are somehow propaganda exercise, and I think the court was very wise in discontinuing the environmental chamber, I think a year ago or so. The second point, very small, the meeting of the court just before the hearing, that is in the, I think is in the rules, or in the, and has been dead letter for many years. I'm happy to hear that it has been revived. I must say that in the Law of the Sea Tribunal, since we discussed the rules, we gave a lot of importance to that meeting. And indeed, this meeting is always held, and in most cases is concluded by formulating questions to the parties that have a certain impact on the conduct of the case. Thank you.
Thank you so much.
It's in the resolution concerning the judicial practice of the court, this possibility of convening the deliberation of the court, and it's usually then a couple of months ahead, not on the eve of the election, because then it's too late, you know.
Ladies and gentlemen, this is time to express our gratitude to the excellent panelists. Thank you so much.